It's matter number C-2007-2073. This is the time and place for hearing various discovery-related motions that are pending. Counsel, please announce.
Yes, Judge. Thank you. Bill Reisner on behalf of the plaintiff, Pima County Democratic Party, and at council table is Manger Sidwa, our first vice chair of the party.
Good morning, Your Honor. Manger Chuck Huckelberry and Chris Stroud on behalf of Pima County, and with us today is County Representative Dr. Moffett.
Counsel, the way that I'd like to have these issues addressed is by what I characterized yesterday of the two pending substantive matters. The first one being the disclosure, the request for disclosure of all election files by the plaintiff, and the second, the request for attorney's fees. So I'm first going to take the protective orders as it pertains to disclosure of all election files. Mr. Reisner, you've made the request for the protective order in that context. I think you're going to need to address the issue of further evidentiary hearings. Obviously, that's a contested point as well, and although it's overlapping, it's still fundamentally separate. So whether I have an evidentiary hearing affects whether further discovery takes place. Let me make sure, you're looking quizzical, let me make sure that you and I are on the same page. I understood from your requests that you anticipated further evidentiary proceedings before me as part of your request for the release of all election files. Is that accurate?
Oh, that's absolutely accurate, Judge.
Okay. And are you also requesting then, as part of the preparation for those evidentiary proceedings, further discovery?
Yes, Judge.
Tell me about the scope of both of them before you tell me about the reasons why they're necessary.
The scope of our proposed discovery?
And the hearing before me.
Okay. It was my understanding that after our last appearance in this court, that the hearing on the 21st would contemplate evidence being presented. And I guess get there through two separate directions. One is we had asked, and the argument last time we were in court was set on our objections to the finding of fact and conclusions of law, and our request for a new trial on the specific issue of evidence relating to whether or not there's harm in us getting all of that information. And the new trial rules provide, as Your Honor knows, that in situations of a court trial, you can have an evidentiary hearing on a single contested evidentiary point. You can take additional testimony. And our objections to the finding of fact and conclusions of law pointed out that in our view there had not been testimony sufficient for the court's determination that there was a security risk, that in fact when we had analyzed testimony from Dr. Moffett and from Merle King, that testimony simply was not sufficient to sustain that finding. If Your Honor was unsure or thought it was or whatever, then we had the second request for additional evidence to focus on that point. Then kind of the third route to the evidentiary point was the ruling itself, which said that after we had received the additional information, we could ask for a hearing, and at the time of that hearing, we could present evidence as to whether or not there would be any harm in giving us the rest of the documents. So what it was, since we were in court at the time to argue on that motion for a new trial, it was my understanding, and it may have been erroneous, that the hearing on the 21st that Your Honor set would be for the purpose of putting on that evidence. Now, in my motion for a hearing, I had requested more time, but nonetheless, I interpreted Your Honor's setting it for 2 hours. In my view, that meant that we had perhaps an hour and they had an hour, and I certainly wanted to avail ourselves of the opportunity to work outside the court and to narrow the issue as to what the county thought the security risk would be, so that we could, in a sort of efficient way, present that testimony. Now, we filed, as part of the request for a hearing on that issue, 2 declarations from national experts dealing with this very case, setting out that they, in their opinion, there was no security issue. So what we've done in terms of the request for discovery is, first, and given the time that is necessary to give advance notice for a deposition, I set first a deposition of the county. It's a 30B6, where the county could bring forth whatever witness they chose on 3 issues. The first issue is basically, I tried to paraphrase the court's ruling, and it says, number 1, all current and future security concerns of the defendant concerning the release of all the remaining post-election data files now stored in the Superior Court's clerk's vault. So that's what Your Honor had said in the ruling. We could have a hearing concerning current and future security concerns. So I wanted to know what those were, and particularly in view of, as we discussed last time, there had been a hearing in front of the meeting of the Board of Supervisors, and at that Board of Supervisors, Dr. Moffat had agreed that there was no possible security concern in giving us all of the iterations of data file for a particular election. So if we're to have a meaningful hearing on the rest of it, I want the county to say, here's what our security concerns are if we give you all the rest of the data. Now, items 2 and 3 deal with run-back and ballot issues, and the way that I framed those issues was based on the county's reply proceedings were in the context of the pleading the county file. They said, well, there's some security stuff dealing with ballot, sizes of the paper, font, color of ink, that sort of thing. And so I was just anticipating, okay, that appears to be, based on what's filed, the only thing that they're claiming would be a security risk. And so, therefore, since I don't predict that issue number 1 would take the length of time for the deposition, I'd like to have someone from the county that would talk about the ballot questions. If they're asserting that these ballot size issues, color, so forth, are in fact security issues, then I wanted to ask someone about that. So I set this 30B6 deposition where they could bring whoever the county wished to explain what their security concerns were. I wanted to do it within a sufficient time that, depending on what the county says are the security concerns, I would have the ability to follow up with whatever is indicated, if it's another deposition or whatever, based on what the county asserts as its security concerns. Now, I, at the moment, would anticipate 2 additional depositions of our witnesses because, as I mentioned, I filed a declaration from the second Thomas Ryan from Ohio and from David Jefferson from California. My thought is that I would schedule either a telephonic deposition or otherwise, if the county chose, to give them an opportunity to cross-examine those individuals, and so that I could offer their declarations and have it confirmed, and perhaps offer their portions of a deposition from them, because given the time frame that the court set and the expense, I probably wouldn't bring them in unless it was necessary. And truthfully, in our view, we're not aware of any security concerns. So that's why it's particularly necessary for us to find out what it is that the county says is a security concern for election data from 1998 to 2005. We know why it's useful to us, but we have no idea other than trying to extrapolate from their pleadings as to what the security concern would be from the county. And we believe it would be highly useful to the court so that that we're able to determine what their concerns are, address those concerns, and try to narrow the issues that are presented before Your Honor. That's the way we see it, Judge.
Mr. Redner, if the county were to decide for its own reasons to provide all of the MDB and GBF files from 98 through 05, does that essentially moot your Rule 59 request for non-trial?
Well, I would say yes. I mean, if we're asking for the data, and if we get the data, it seems to me that's that. That's so yes.
Yes, I think this is a little confusing. The merits of what counsel was talking about, I think, is a little bit premature. That's something that we would discuss at the April 21st hearing when we were discussing the new set in the February 25th ruling entry, the pending motions in this matter, which are being heard on that date for 2 hours. There's the motions for new trial, the motions for additional evidence. Essentially, I guess that's a motion for reconsideration. Those are to be heard on April 21st. Nowhere in that minute entry does it authorize plaintiff's counsel to go ahead and conduct discovery in advance of you ruling on those motions. Nowhere in your decision from December 18, 2007, does it authorize post-trial discovery, which is what counsel is trying to conduct here. And I think counsel is mischaracterizing what you stated in that report. Was that you said you denied plaintiff's letter request for every filed entity extension of GBF on MDB. Such denial is without prejudice to the plaintiff to re-urge the record request after it's had the opportunity to study the files from the 2006 elections and to address the current and future security concerns raised by Pima County arising from the disclosure of the MDB and GBF files. So to me, it seems that there's 2 steps there that the plaintiff has to go through. One, they have to study the MDB files from the 2006 elections, and address the concerns, the security concerns already raised by Pima County in discovery prior to trial and at trial. To my knowledge, that hasn't occurred. So anything at this point would be way premature. I think plaintiff has now the databases that you ordered Pima County to release. And Pima County voluntarily released an additional 300 databases. There's ample information there for plaintiffs to go through and review and see if there's any issues there that would be brought to the court's attention. That hasn't occurred as far as I'm aware. And I think that's pretty telling, but there's nothing there. And there's certainly no justification to go ahead and release further databases, which reduces the security of future elections.
When would Pima County be in a position to state to the court any further security concerns that arose out of the release of the database files that I ordered, as well as the ones that were voluntarily released?
Well, I think Pima County's already presented evidence at trial on the security concerns. We've also, in response to the motion for the trial, have raised some of those security concerns as well. But I think that's something...
Let's go through this, because since there isn't some question as to what I anticipated in my order of December 18, I want to make this clear. I very specifically did not specify deadlines, because the nature of the testimony had to first address whether any files could be released. As you know, I made a determination that there could be a release of certain database files. And then I anticipated, based on the testimony I heard, that there could arise out of that release security concerns. I didn't know how long it would take for those security concerns to come out, and I didn't know how long it was going to take for the plaintiff to analyze the files. Therefore, I very specifically omitted any deadlines by which either the plaintiff should analyze the information or the defendant should express the security concerns. It was also my intent for the parties to have the benefit of my factual findings and conclusions of law, so that you could make a determination as to whether you wish to have this be essentially a final judgment and therefore an appealable judgment. I was waiting for either someone to file a notice of appeal, or, as the plaintiff has chosen to do, file a Rule 59, which essentially will stay the notice of appeal having to be filed. So the plaintiff has taken that step, and I will have to address the Rule 59, and I intend to rule on that. However, my order still leaves open the possibility of considering additional requests within the context of this order prior to it being a final judgment. Once it's a final judgment, then, especially if someone files a notice of appeal, then I lose jurisdiction in any of it, except to further the case. And procedurally, that's how it would proceed, is that you would then have it work through the appellate process, and we would all know what modifications, if any, will be made to my ruling based on the appeal process. But it has been purposefully left open, and therefore I need to know now, if you can tell me, whether the county is in a position to state, prior to there being a final judgment, whether we're going to present security concerns.
Well, again, I think we have presented security concerns.
Well, let me do security concerns beyond what you presented at trial, because obviously at trial, the files haven't been released. You now have additional information that neither you or I could have considered on December the 18th. That's right.
Yeah.
So, Your Honor, I think there's two issues here. One is the procedural process that has occurred up to this point as far as motions of the hearing today. And two is whether the court, in its discretion, wants to hear additional evidence. And if the court wants to hear additional evidence as far as security concerns, Pima County will be prepared to present additional information in that regard. That doesn't excuse the actions taken by plaintiff's counsel in this case, which is to go ahead and unilaterally use the power of the court to start post-trial discovery, which was not authorized by the court, nor under the rules of procedure. I think those are separate issues.
Let me first address your question about do I wish to have an evidentiary hearing. The parties will tell me whether they want to have an evidentiary hearing. It all depends on what the parties believe is the status of the case and what is the relief requested. The plaintiff has made clear that it wishes to have a relatively short evidentiary hearing, and one in which I will probably receive declarations or deposition testimony so as to focus the issues, but that the testimony itself will be limited to approximately 2 hours. Now is the opportunity for you to find out whether the county wishes to have an evidentiary hearing and relatedly whether you oppose the request of the plaintiff to have an evidentiary hearing. And I understand the plaintiff's request to be they want all of the files going back to '98. And you wish to have an evidentiary hearing, either an hour here in court as well as whatever you wish to present me by way of declaration, affidavit, or deposition transcript.
I think that is the motion for the release of all the additional files, which was to be heard on April 21st. So, in that regard, and that was to be heard April 21st.
Well,
so,
and I'm not going to make that decision today, but you need to tell me now whether as part of that motion, and what I assume is your opposition to it.
We would oppose having an evidentiary hearing. I don't see any justification for it at this point. However, if the court decides to have an evidentiary hearing, then we will present rebuttal evidence or opposition evidence.
Well, if the county is going to produce evidence about its security concerns that it's developed since December the 18th, you're going to have to do it by way of an evidentiary hearing. Or at least you're going to have to submit new evidence to me.
I don't think it's necessary, Your Honor. I don't think that that evidentiary hearing is warranted. However, if the court deems it necessary to hold such an evidentiary hearing, then we can will present evidence to that hearing.
In other words, your legal position is you'll stand on the evidence about security concerns that was presented at the trial in December.
As long as, I mean, if there should be no further evidence produced in this matter. It's always within the court's discretion to hear additional evidence if the court determines that that's warranted. If the court determines that that is warranted in this case, then we will present additional evidence. However, I think this case is closed. We're done. We've heard there's been ample opportunity for discovery for the plaintiff prior to trial on all the issues that he's discussed here today. There's no newly discovered evidence that through reasonable diligence could not have been produced at trial. They had an opportunity to present evidence at trial. We had an opportunity to present evidence at trial. At some point, a matter has to end. We believe that this matter is ended. Now, if the court determines that it wants additional evidence, then we will present additional evidence. That's up to the court.
I understand your position now. Thank you. Is there anything additional, Mr. Rosenberg, on that point?
No.
Let's move on then to the second issue, which is the request for an evidentiary hearing by the defendant concerning attorney's fees and the motion for protective order by plaintiff's counsel.
Yeah, I'll handle that. At this point, we've presented an opposition to the motion for attorney's fees submitted by the Democratic Party in this case. And as I had indicated to you previously with respect to this matter, there are really two aspects about that, our opposition. And that would, and how the court deals with those aspects informs the court's decision as to what this evidentiary hearing is going to look like and whether we need one. So let me just back up a second and talk about those two. The first issues, as we've raised in the opposition for attorney's fees, is that the only attorney's fees that are available under the statutes at this point are those available potentially under 39-121.02, which is the public records law. And that requires the initial threshold determination that the Democratic Party substantially prevailed. And our motion, if you take a look at our opposition, rather, to the plaintiff's motion, asserts that getting only 2 out of 1,156 some odd files does not mean that they substantially prevail. So if indeed the court were to rule on that, and there wasn't really significant case law cited by the plaintiffs in this case to refute that proposition. But so as a threshold matter, if indeed we prevail on that point, then indeed his motion for protective order and all that stuff is frankly moot, and we don't need the additional discovery, et cetera, that Mr. Jerkovitz will talk about. On the other hand, if the court determines that it doesn't either want to address the issue of substantially prevailing at this point, and wants to preserve that issue for the hearing, the eventual hearing on the motion for attorney's fees, which is, I think, where the court was going the last time on this, then we have to preserve our options. We would need an opportunity for an evidentiary hearing. We would need to be able to conduct some additional discovery to be able to preserve our rights. There are other aspects of the motion, for example, whether from the face of the billing records that have been submitted by counsel in this case, whether one could reasonably determine whether that time is reasonably spent on this case or not. And the issue in that specifically, Your Honor, is the the plaintiffs in this case block billed whole batches of time, and in there, it's shown in our opposition to the attorney's fees motion, are detailed chart showing what our specific objections are. And the concern is why we wanted to have an evidentiary hearing is that if the court was going to put the burden on us, which I don't think is proper in this particular case, but in the event that the court determines that we have some sort of burden, then we want an opportunity to conduct discovery. Then we want an opportunity to be able to present what we find to the court, to be able, in addition to our written motion, to be able to dispute those issues. So at this point, again, we think our legal position is frankly, again, an evidentiary hearing isn't necessary because they don't meet the threshold substantially prevailing as a matter of law. But if indeed the court determines it wants to go forward or rules against us on that point, and then we're talking about the actual bill itself and how much of the portion is owed or not owed or established, then we would need an evidentiary hearing to protect the county's due process interests in this particular case and have an opportunity to take a look at that bill essentially without this reason. And what we would need is that hearing should be scheduled. I guess you wanted to address the issue of scheduling with respect to that. Again, I would think that would need a couple hours if we're going to have a hearing with respect to that, if there's going to be detailed testimony with respect to that. And that should be held down the road in advance of one, assuming that we are able to get the records that we've requested, and assuming that doesn't lead to any request for additional discovery, we would need at least probably about 4 to 6 weeks to be able to analyze what we have and be able to prepare for that hearing. Thank you.
What do you anticipate would be the testimony of that hearing?
Well, I don't know if necessarily it would be testimony. In fact, if the billing records themselves do not confirm or be able to establish or to be able to break out the appropriate amounts of time that were lawfully spent versus time that we can test is not billable in this case, then it could be documentary, in which case then it would be much shorter. If, on the other hand, there still is some ambiguity, there may be a requirement to have some testimony on that point. It's hard to tell at this point since we don't know, and it's the nature of the bill that was submitted, again, which we think is even if you get past the point of whether they substantially prevail, whether it even meets the China dollar requirements in the first instance, and that's a big portion right there. the board can make that determination, by looking at the pleadings and what they've submitted right now, make that determination. What we're talking about is essentially third tier stuff, where the court gets past those first two hurdles and decides it wants to hear, what was reasonably billed and what wasn't, how much of a block billing was devoted to contact press, for example, which are things that are clearly not legal work to advance the case, those kinds of things. And that's what we need to parse out. From what has been submitted by Mr. Reisner, you already know, for example, the affidavit, and you got the correction as well on his application. He says at least 80 hours were not appropriately billed, and they ended up showing up on that, notwithstanding his under oath statement that goes with the application for attorney's fees, saying that the material was properly billed. It's obviously he's at 80 hours that weren't. I know.
I'm not asking for argument on the substance.
Yeah, but that's what I'm telling you is that I think that that's where we're at here anyways, is that if you're at this third tier issue, then we may require allowance in terms of testimony or other documents or evidence to parse that out.
That's right.
Yeah, Judge, this part of the case has reminded me that I've had a charmed career. I think in most of my career I would either get criminal fees in advance or percentage fees. And I think once before, and it actually related to the Democratic Party, I had a contested fee matter, and I can only recall one other time where I've submitted these kind of fee requests. So it's part of it's new to me, but I was intrigued by the case that counsel attached to request for an evidentiary hearing. This National Association of Concerned Veterans and Secretary of Defense case, and it says in there that discovery requests should be precisely framed and promptly advanced before final opposition papers are filed. I had filed a motion for protective order in this case because the last time I was in front of Your Honor and with the attorneys here, I mentioned that I had a trial that was to begin today that was really incredibly complex. We have 13 Mexican national clients, additional Mexican national witnesses, 4 fatality rollover case. We have to get approval for most of the witnesses from the immigration authorities to have them paroled in the United States. In our small office, we were up to our eyeballs in dealing with that case, and then right after I tell them I can't do anything, they set at a time period where they want a bunch of my documents where I would need to look at it and see what's involved with other clients and to redact privileged information from those. So I filed a protective order primarily in that regard because I viewed the timing, and I viewed the request for all those documents after they had filed 2 opposition pleadings with great detail as pretty much harassment. But if I'll leave it up to Your Honor. If I can provide the documents with sufficient time, and we can have a hearing. I don't personally think it's necessary. I think there's sufficient information for the court to make its decision. But it's a new experience for me. I'm willing to spend whatever time they want to spend on this this aspect of the case if it's required.
I understood your objection to primarily one timing.
Right.
Now that you are not in that wrongful death case, what do you believe is a reasonable time for you to respond to this?
I don't know, maybe if I could have 2 weeks. My wife has added on a trip to see relatives once I had some extra time. So.
Now, let me check my schedule so we can finalize a couple of these other dates. Council, I'm reminded yet again of, I think, what I told you when I was trying to schedule this before. My calendar for April does not have any free time other than what I've already given to you. And that even goes into May and June as well. This matter can't wait that long.
The county doesn't have any objection to pushing.
I understand, but I do want this matter to be in a final judgment form long before July. It's my intent to have this be in a final judgment form in April. So I'm going to keep with that schedule. Now, as a practical matter, then, short of you being on call, and if, as is typically the case, one of my trials goes away, then I could call you in on what basically would be 48 hours notice and have you put it on. That's how we used to do things, of course, in the old days. I don't think it's realistic for this matter. It's not fair to everyone. I never appreciated it as an attorney. And so we're going to stick with the April 21st 2-hour time period. What that means then is it's not realistic for me to hear only evidence on those days because it's very difficult to have any substantive evidence come out in the space of 1 hour. If you each get 1 hour, the witnesses barely have time to introduce themselves and offer an opinion without any support. So I'm going to end up relying on the testimony or the declarations that you will develop prior to the April 21st hearing. This will not be as limited as it seems, because I will also rely on the 4 days of testimony that I heard in December. This is not occurring brand new, so to speak. What we're going to do now is I'm going to authorize specific discovery that can occur. I'll also authorize specific declarations or affidavits that each of the parties can present. In other words, we're going to take the time right now, because you've only got a month to put this together, for you to outline what your presentation is going to be from an evidentiary perspective on the 21st of April. Mr. Roger, let's start with the plaintiff. Which witnesses do you want me to testimony? Do you wish me to consider? And I'm referring either by way of deposition or by way of affidavit.
Judge, there's two that we filed. So those are two witnesses and two declarations.
For the purposes of having a clear record, you better
That's
give them to me by name.
Thomas, I believe it's P. Ryan, and David Jefferson.
Thank you. Anyone else?
I may have testimony from runback relating to ballot issues, but part of my problem on knowing now what I'm going to produce is I don't know what their alleged security concerns are. That's why I needed the 30B6 deposition. So certainly I want the 30B6 deposition because I want the county to tell us what their security concerns are now.
Well, I will ask Mr. Berkowitz whether he still intends to stand only on the testimony that was presented at trial, in which case you already have that.
Yes.
If you intend to present someone else or some additional testimony from an existing witness, then you'll know that. I'll give you the opportunity for a reply since it's plaintiff's privilege here.
Okay. And I may present testimony from Dr. Thomas Ryan in Tucson.
Do you call his middle initial?
No.
Should we just refer to him as Dr. Thomas Ryan? Does that distinguish?
Yes.
Thank you. Anyone besides those three? Ryan, Jefferson, and Ryan?
Perhaps, I believe his name's William, is it Newman? Well, there's
Sir?
I'll give you the opportunity to consult with your client now. Mr. Berkowitz?
At this point, assuming now that you're going to hear additional evidence.
Well, Mr. Berkowitz, let me be very precise here. I am going to consider additional evidence that will be submitted either in affidavit or in deposition form.
Understood.
Okay.
And since that's the case, Pima County will be presenting additional evidence from Royal King, Dr. Moffitt, and the representative from the Secretary of State's office.
As I recall from the prior hearings, wasn't someone deposed, was Mr. Canfield deposed in the prior matter? Is that what you're thinking of?
Probably, but you obviously have to check the Secretary of State's office. Your Honor, I think we need to kind of define what issues we're actually going to be addressing so that everybody's on the same page. Because otherwise, this is going to be essentially run open book for a new trial. So what specific issues do you want to address with the hearing? It's just the future security concerns raised, or that will be raised now because of the disclosure of the databases. Is that it?
Yeah, I would expect that that would be the major issue. That was what I asked Mr. Reisner. If all of the files were to be disclosed voluntarily, would that move the Rule 59 issue? And he indicated that it would. So the only thing that is pending of a substantive nature is the plaintiff's request for all the remaining files and defendant's objection to it for security concerns. I've already heard your security concerns that existed as of December of '07, so I would expect, but I'm not trying to micromanage your case, that you would tell me about new things that you couldn't have told me about in December, because the world has changed, things have been disclosed, and one of the points of testimony that I heard was that if these files were to be released, certain consequences could arise. This is the defendant's opportunity to tell me about what have been the consequences that have arisen as a result of the files that have been disclosed thus far.
Right. And will the court be addressing prospectively what's going to happen as far as the 2008 election? Because I don't want to go through this again.
I want to hear from actually both of you on your position. That is a separate, but it's a very important issue, and I haven't heard Mr. Reisner make a request for injunctive relief as to future elections. Thus far, this has been tried on the basis of releasing existing files. I recall that somewhere in these files there is some mention of an injunctive order pertaining to future elections, but that wasn't the point of the testimony or of the request of relief. And, are you asking now for an order, up or down, on injunctive relief going forward?
I think for judicial economy, Your Honor, this issue needs to be resolved one way or the other. And as far as whether the plaintiff is going to be able to make additional public records requests in the future, and whether we will have to go ahead and provide those databases as every single election comes up.
Yes.
Or whether the security concerns, if we raise sufficient security concerns, then the court's going to say that those files don't need to be disclosed. I think that's something that the court needs to address.
Mr. Reisner, Mr. Herdowitz has joined that issue. Do you join in his request that I, as part of my final order, address whether these files have to be released in the future?
Judge, we filed our amended complaint, requested a declaratory judgment, and part of what argued at the last hearing and one of our objections to the finding of fact and conclusions of law was the imprecise statement where Your Honor had said that these files in the future could be provided days and weeks after the election. And if you recall, I pointed out that there's a state statute that requires that elections be challenged within 5 days with specificity. So I had not understood that there was any issue about whether they needed to be provided in the future. My understanding of the issue is when they needed to be provided in the future, and the declaratory request we wanted is an order saying that it needs to be provided in sufficient time for us to be able to, and other political parties, candidates to be able to look at the data in time to file an election challenge.
So I think that you do join with the county in asking a very specific order that specifies when the files have to be released and whether they can be released in the future.
Well, he said whether.
Yes.
I wasn't aware that was in doubt.
Well, the county certainly opposes it. The county opposes any release of records other than what I have ordered or they voluntarily release. That's my understanding.
Okay. Sure.
One final.
Yes.
As far as discovery between the parties for this, then we're going to be able to take depositions on the various issues.
I haven't talked about that yet.
Okay.
We're going to get to that point. Mr. Reisner, have you submitted all of the affidavits that you intend to submit?
No, Judge.
When can you submit the affidavits that you want to rely on? Here's where I'm going, counsel. I assume each side will reserve the right to take a deposition of an affidavit. Or, alternatively, if you think it comes out better, I suppose one of you could notice the deposition of your own person, similar to a deposition being used for trial purposes. You decide how you want to do that. But what I need to do is set a deadline so that if a party intends to submit that witness's testimony by way of affidavit, then the other party has an opportunity to depose the person about that affidavit. And the later you put out the affidavit, then the more crunched it's going to be at the end.
Sure.
So when can you get the affidavits? Because then I have to set the deposition by that time. And I want to avoid a situation where everything is being done in the very last week.
I suspect I can get my affidavits by the end of next week. But again, I emphasize one problem we have is in preparing an affidavit is I don't know and can't tell our people what they claim the security concerns are. So I can file affidavits and have people file affidavits saying we're aware of what these files are that contain and there are no security concerns. Bingo. When they come up with something, then I've got to ask our people about those issues.
Essentially, your request is that the defendant provide his affidavit first, and then that way you'll be in a position to respond.
Sure.
That's a practical failure on it.
Well, just a second.
It's not our burden.
Mr. Jurgowitz, what I'm concerned about is if I do it the other way, you're going to get a reply affidavit closer to trial. Now, I guess you can choose, and I will let you choose because it is the plaintiff's burden, whether you wish to have reply affidavits or you wish to have responsive affidavits.
Jimmy, pull back.
No, I think we would prefer that plaintiff disclose his evidence first and we'll respond back to that.
Well, what I will do then is set a deadline for plaintiffs' affidavits will be March the 27th, 2008. The defendants' affidavits will be due on March the 31st, 2008. Mr. Woods, you expect to have 3 affidavits for Dr. King, Dr. Moffitt, and then a representative from the Secretary of State's office.
Correct.
I would like counsel to discuss among yourselves and set up a deposition schedule for these 5 witnesses. Actually, for all 6 witnesses. I think the county should try and get that designation from a representative of the Secretary's office as soon as possible. Because here's what I don't want to have happen, counsel, is that you wait until the end of March to see everybody's affidavits, and then you decide whose deposition you're going to take, and then you find out that half of them are in Europe or some other scheduling problem. Now, this week is when you have to schedule those depositions. We need to keep this on track. It's a lot easier to cancel a deposition than it is to schedule it. So before you even leave the courthouse today, I'd like you to sit down with each other's calendars and then start planning out how you schedule the depositions on the assumption that you'll want to take it. If you decide not to take it, then you just cancel the deposition. But including the entry and a minimum for today, that I do want counsel to confer and come up with what I refer to as placeholder deposition dates and times that you will cancel if you choose not to take that person's deposition.
Judge, there's
Yes, Mr. President.
2 additional. I would like to check with John Washburn. I may need a deposition from him, or declaration, and then possibly Professor, I believe his name's William Newman at the University of Arizona.
Let me go through whether each of these people is going to testify as to truly separate issues, because you've now listed 5 different people. Are they really going to be separate?
Yeah, possibly. Well, we have 2 declarations from the Thomas P. Ryan and David Jefferson. William Newman and Thomas Ryan and John Washburn have been involved with the actual examination of the data. And John Washburn's a well-known national expert that I'd like to check with him. I don't know if he would be providing one, and really without talking to him, I don't know how secondary information would be. But they certainly come from different perspectives in the sense that it's John Washburn, who's in Wisconsin, has been participating on a national level, and at the University of Arizona, they're hosting the data and what they call a wiki, where the scientists can access the data and have been developing a process of looking at it. And that's something that our Tom Ryan and has been involved with locally as well as other scientists. So they do provide a different perspective.
To limit each side presenting 3 affidavits. Now, Mr. Reisner, I will give you the option, if you find after consultation with Washburn or Newman, that one of the 2 lines or both of their affidavits have to be withdrawn. But the issue should be narrow enough that 3 affidavits or affidavits should be sufficient. So we'll show for the purpose of the minute entry that both sides are limited to 3 affidavits, and that the list that the plaintiff has presented from which it will present 3 affidavits is Thomas P. Ryan, David Jefferson, John Washburn, William Newman, and Thomas Ryan. The defendants have presented Earl King, John Moffett, and the Secretary of State representative. Mr. Reisner, if you can limit your list of names sooner than March 27th, I think everyone would appreciate that, because otherwise you're going to try and schedule 8 different depositions.
I will try to do that. But I want Your Honor to understand the complications, since we don't know what they might say. It really creates a bit of a problem. But I'll certainly try to do that.
Okay. Counsel, please arrange for any deposition transcripts that you wish for me to review to be available by the 21st. My preference would be that you get it to me by the 18th of April. But if for some scheduling reason that's not possible, then I'll work with your schedules. The 21st is a firm date, though. And it's better for me, and I think better for you, if I have the opportunity to at least review the transcripts, if not actually study them in detail. That's why I'm requesting that you get it to me by April the 18th. And I will take 2 out of 3 or something of that sort. In other words, you don't have to give them all to me at once. I will be reading them as they come in. So if you can get them to me earlier, then all the better. I anticipate enough work that I'll be doing a piecemeal in any of that. Counsel, I think that takes care of plaintiff's motion to release all of the records and plaintiff's Rule 59 request. Is there anything else on that substantive point that I have overlooked? Now let me turn to the request for attorney's fees. The court finds that plaintiff's motion for protective order is moot in that plaintiff's counsel can comply with the subpoena. Mr. Reisner, I'm sorry, I didn't write down the specific date by which you said you could respond. Was that 2 weeks?
I think, yes.
Okay. Plaintiff's counsel is to respond to the subpoena no later than March 28, 2008. Counsel, I'm going to give you another oral argument date. Absent of extraordinary circumstances, I don't anticipate having an evidentiary hearing on the statute, and if that new statute was in place, they might have reached a different decision. It's not helpful to me then. I will appreciate briefing on similarity between Arizona's new statute and the existing federal statute. There's considerable case law on the existing federal statute. I'm not sure all of it is applicable, but, and there are differences among the circuits. But I think that you need to address that because this may be a case of first impression. And as you probably know, there's been quite a bit of case law that's come down within the past 2 years on our old statute, which is, for most purposes, no longer applicable. Give you that new date. We're all here, what I expect to be just oral argument. Here then on May 5 at 2 p.m. for 1 hour. And the opposition should be filed no later than April 21st, 2008. The reply brief should be filed no later than April 30th. Are there any questions about the schedule for the attorney's fees request? I am denying without prejudice the defendant's request for an evidentiary hearing. The without prejudice part is simply because I recognize that Mr. Reisner's response to the subpoena could raise issues that the defendant is not aware of at this point, but that my strong leaning is that short of a fairly serious question or allegation, I'm going to be making my decision on the papers that are submitted, not on having Mr. Reisner testify.
Just I said one question on this.
Yes, sir.
So I understand that I don't get a 30B6 of asking them what it is. I've got to limit myself to these 3 names that they mentioned, those 3 affidavits. Is that the deal?
Yes, sir. And we'll make it very clear in the minute entry that to the extent that the plaintiff has requested a 30B6 deposition, the request is denied in lieu of this other procedure that I have established. Any other questions, Counsel? Okay, Counsel. Thank you. I will see you all next month.